The contract says if the seller is late, it's $100 a day penalty for each day they're late in delivering. They're 10 days late. That's $1,000. But the buyer really only suffered $50 in damages from the late delivery. Does the seller pay $50 or $1,000? Hi, I'm Michael Dorff, and I'm the Executive Director of the Lowell Milken Institute for Business Law and Policy here at UCLA School of Law. In the next few minutes, I'm going to explain the term liquidated damages and when courts will enforce a pre-agreed term for the amount of contract damages. First, our vocabulary term for the day, liquidated damages. A liquidated damages clause in a contract is a provision that says how much a party will have to pay if that party breaches the contract. The idea here is instead of fighting after the breach over how much damage was done, the parties agree in advance how much they will pay if each one breaches. It's kind of like a prenuptial agreement, but in business. These liquidated damages clauses are particularly popular in certain types of contracts. Contracts for construction, events, and delivery are all areas which are very likely to see a liquidated damages clause. Are these clauses enforceable or not? Of course, it depends. Three things have to be true for these liquidated damages clauses to be enforceable. First, the damages have to have been hard to estimate when the contract was made. So at the time the parties were bargaining, it has to be unclear how much each one would suffer if the contract was breached. Second, the amount they agree to as liquidated damages has to be reasonable once they see what the damages actually were. So they have to have been not exactly right, but at least reasonable in their estimate of how much the damages would be. And third, the damages have to not be obviously punitive. It has to look like the intent of the parties was to make a reasonable estimate, not to punish any party that breaches. In contract law, we're not about punishment. This is not criminal law. We're about making parties who are injured whole again. We're about healing. We're about love. We're about fixing things. It's not about punishment. If the liquidated damages clause looks like it's intended to punish a party for breaching, the court will strike it down and not enforce it. Common example, a wedding venue. Suppose you're going to get married and you contract with a wedding venue for $50,000 to host and cater your wedding. Nice wedding. The contract says if you cancel with at least 6 months notice, $5,000 of damages, liquidated damages. With that much notice, the venue can probably find a substitute couple to pay for your date. However, they probably will have to bear some expenses marketing and searching for that other couple. $5,000 seems like a reasonable estimate. It's hard to know exactly how much it will cost, and it's not intended to punish. That's enforceable. On the other hand, $50,000 penalty for cancellation 6 months in advance, totally unreasonable for the same reason. They can probably find another couple with that much notice. $50,000 in liquidated damages for cancellation with only 1 week's notice also looks reasonable. With only a week's notice, it's unlikely the venue is going to be able to find another couple to get married on that day and pay for the venue. So paying the entire contract price with only a week's notice seems like a reasonable liquidated damages clause. So to sum up, liquidated damages clauses can be enforceable as long as they are reasonable and not intended as a penalty. Have you ever paid a fee for being late that seemed way too high? Comment below and follow for contract law that actually makes sense.